Of course, the idea that we should leave the European Court of Human Rights so that we can get our own way with managing migration is a cuckoo clock nonsense. It's an absurdity because we still have to deal with the Refugee Convention of 1951, which Winston Churchill signed and encouraged, and we can't avoid our responsibility with that. More than that, as I pointed out the other day, we are responsible for the legislation, the rulings, the legal rulings, which make it clear that passage through a safe territory like France or Spain can take up to 70 days. So unless we wish to produce legislation that overrules the judge's statements in 2019 and before, then we are still bound by these rulings, and getting out of the European Court of Human Rights will actually not sort the problem out legally as far as Suella Braverman is concerned, and she is a twit if she thinks it will. This is a distraction and a nonsense, and anybody with even any legal training will be able to say that. The rhetoric which is coming out of 10 Downing Street and out of the Home Office is pie in the sky rubbish. So we've got 60 backbenchers who think that we should be leaving the European Court of Human Rights. They're quite right. America is not part of the European Court of Human Rights. Of course it's not. It's not part of Europe. But leaving the European Court of Human Rights makes a statement that we are on a par with Russia and Belarus. If that's the reputation we want, it is rapidly the reputation we are acquiring, and we may well find that we are even further snubbed by our European friends. So the fact that we have a number of migrants coming to our country, and a number of migrants coming to our country illegally, or at least coming to our country illicitly, that we've now defined as illegally under the November 2022 Nationality and Borders Act, it needs to be put in the wider context that there is a migration problem that is affecting Europe particularly, and the European continent. And the best way to deal with that is with an international European-wide convention, which would look again at the 1951 Refugee Convention, which is the biggest stumbling block, not the European Court of Human Rights. No court is a stumbling block. The courts simply enact the decisions of the various parliaments. And if those parliaments are too stupid to make those decisions and to enact laws which are straightforward, then they shouldn't be surprised that they get tied up in knots by courts. So we come back down to the same issue, that the people who are enacting the laws and the people who are defining the laws and putting those laws forward, like Suella Braverman, are inadequate. And you can't rail against the people who are doing their jobs, the lawyers, simply because of your inadequacy. The deportation flights to Rwanda. Rwanda should never have been chosen. Start looking at the details of Rwanda's contempt for the refugees it is looking after. What we want to know is where is the report? Where is the investigation into the deaths of 13 Rwandans shot in 2018? And then we need to see, then we're very happy to listen to Miriam Cates and Danny Kruger and all these various MPs, including John Redwood. But these MPs, are any of them lawyers? Do any of them really know what they're talking about, or are they simply spouting the rhetoric that the Home Office is encouraging them to say? Okay? The total number of refugees is going up. Of course, it's going up, but it's going up across Europe. We are not the only country that is concerned about this. We could lead the way. And if we don't, another European country, or Europe itself, will lead the way and call for this international convention. And again, we're playing catch-up. If that's what we want to do, that's our option.